Mr. Chauke, can we just start with the formalities? In front of you, you should have your witness statement that starts from page 1 to page 121.
Yes.
Is that correct?
Yes.
Okay, you've read it?
Indeed.
And you confirm that it is true and correct?
I confirm.
And that it is binding on your conscience?
Indeed, I confirm.
Yes, thank you. Now, you've obviously been listening to the case for or against you during the course of this inquiry. Is that correct?
Yes.
Yes. And so you know the gist of the allegations against you?
Indeed.
Yes. Now, and you've looked at the terms of reference?
Yes.
Yes. In relation to the allegations that are made against you?
Yes.
And you understand the case of Cator Manor, where there are certain allegations that you did certain things incorrectly?
Yes.
And you are familiar with the case of Lieutenant General Mulli?
Yes.
Yes. And so there is nothing you would say from the terms of reference which substitute as a charge sheet is not clear to you. You're happy to proceed?
Yes.
All right. Thank you very much. Now, in your statement, we can skip paragraph 1 to paragraph 7. And then we start at paragraph 8, where you say that in relation to Cator Manor, you were not the decision maker. What are you trying to convey there?
I'm trying to convey, Chair, that the decision was made by the acting NDPP in respect of the racketeering charges.
Yes.
Advocate Chauke, try to speak louder, please. Yes, maybe you should. Is it possible for this mic to be pushed a little bit towards Advocate Chauke? I see there's virtually no space for him to put his files. You can even use the desk if you wish. You may put some of the stuff on our desk, just at the corner there, Advocate Chauke.
No, thank you, Chair.
Are you comfortable?
I'm comfortable, thanks.
Yes, thank you. Please speak loudly. Thank you.
So you say the first thing is that you the decision to authorize racketeering charges was taken by the acting National Director of Public Prosecution.
Yes, indeed.
And it's common cause that that person was Advocate Jiba.
Yes.
Yes. Now, it's also common cause here that there was a range of prosecution decisions that were taken in that case, correct?
Yes.
And who took those?
Most of them, they were taken by the prosecution team, to which I would have access and have come to know about them and interface myself with them. But the ultimate decision in respect of those racketeering charges was made by the acting NDPP.
Yes. Now, and then in relation to the case of Lieutenant General Mulli, in that one you accept that you were the decision maker?
Yes, I'm the decision maker in respect of the General Mulli matter.
Yes, and why do you accept that?
It's because I've considered the representations which were made to me, and I ran through the process and ultimately made a decision.
Yes. I just want to also ask you just a general question. You know, we are in 2026. The inquiry started against you in 2025. But the decisions that we are talking about are decisions taken in 2012. And in between, there have been various national directors of public prosecutions. Now, I want to ask you, starting with Advocate Jiba, did she ever see any need for you to go through a disciplinary process in relation to the decisions you took on the case of Lieutenant General Mulli or in the case of the racketeering case of the Cator unit?
No, Chair. She did not.
Yes.
To my knowledge, I'm not aware of that she had any inclination that there was anything wrong with those decisions.
Yes. Now, we know that Advocate Jiba was succeeded by Advocate Ngasan.
Yes.
Did Advocate Ngasana ever think that there is any reason why you should go through a disciplinary process in relation to either the Mulli matter or the Cator matter?
Not at all.
Yes.
Not at all.
Did you ever discuss the matters with him?
Yes.
And what was his attitude?
His attitude was that the prosecutors will differ, others will say it differently, others will say it positively, depending on the facts and where somebody is coming from.
Yes.
And naturally, in respect of the Cator matter, he indicated to me that he was uncomfortable that I should continue to be the coordinator of the team, and that the acting DPP at the time, Advocate Nogo, should take over and coordinate the teams. In respect of the Mulli matter, he made a decision ultimately that confirmed my decision about the matter charge in respect of General Mulli.
Yes.
Advocate Toby, if I may, for those who do not or have not read this record or have not followed the proceedings, I propose that you mention what these decisions are. The one as far as the Cator matter is concerned, and the one in relation to the Mulli matter. Very briefly.
Thank you, Chair. The one in respect of the Cator matter is the decision to charge General Boys and Mulli and officers of the Cator with poker, that is racketeering charges. The one in respect of General Mulli, it's my withdrawal of the murder charge and referring it to an inquest, and the final decision which was made by me not to proceed with the murder charge but to proceed with the other charges. That decision was taken on review, and after the review at the SCA, the matter was placed before Mr. Ngasana, who was the NDPP then, who made a similar decision, confirming the decision that I had made not to institute murder charge against General Mulli.
Yes, thank you.
Yes.
Thank you, Chair.
Thank you. So we are now in the stage of Advocate Ngasan. So in relation to the decisions that you played a role in, which is the coordination over the criminal prosecution of Major General Boysen and others, and the decision-making in relation to Lieutenant General Mulli. His view was that there was no need for any disciplinary steps against you.
Indeed. In fact, he did not see any misconduct or improper conduct on my part.
Then we know that Advocate Ngasana was replaced by Advocate Sean Abrahams.
Yes.
What was his view in relation to these two decisions?
Advocate Abraham, in fact, invited me into a meeting when he had just been appointed with the prosecution team and those who were part of one way or another part of the Cator matter, in which he acknowledged my contribution that I made there, and then he thanked me for my contribution in that case.
Yes. So, but what was his view about whether your role in the Mulli matter or your role in the Cator matter amounts to misconduct, that you should be facing a disciplinary inquiry?
No, not at all, Chair. In fact, like I indicated, in respect of the Cator matter, he thanked me for the role that I had played in assisting that, because he was going to reconsider those that matter of Cator matter. In respect of the Mulli matter, it was just an information sharing, because the case had been placed on the roll, and the decision of Mr. Ngasana already was final. So he had really no issue or to consider, especially in respect of the Mulli matter.
Yes, and then Advocate Abrahams was then replaced by Advocate Batoyi.
Yes.
Is that where things changed?
Indeed.
That's what I don't understand. I mean, 3 NDPPs have looked into this, and they have said, according to them, there is no basis for this. And then some 15 years later, someone else comes and they say, no, we should resuscitate something that happened 15 years ago. What is your comment on that?
My comment, Chair, is it appears suspicious, the motive. But as one would understand, there was this thing of the MK being captured and whatever, and I think Advocate Batoyi, I became one of those that would have to undergo a form of some discipline or a form of some inquiry, because the media narrative and what she came to say within the NPA was that there are prosecutors, one or another, who are in the NPA whose names were mentioned, the Zondo Commission, and who also were supposed to file statement as the Zondo Commission. But that, of course, did not even consider that the issues that were being raised at the Zondo were dealt with by the other NDPPs as well.
Well, you were here when I asked Advocate Batoyi whether she had any evidence of state capture implicating you, and she said she didn't.
Indeed, I'm aware of that.
Yes. Now, how many other prosecutors were placed in some sort of a disciplinary process when Advocate Batoyi came?
About 6.
Who are they?
Advocate Musing,
Yes.
Advocate Noko, Advocate Maema, Advocate Matenjwa, and Advocate Ntlagaza, and the other one who I do not even understand how he's related to Cator and all sort of things, is Advocate Mukhatla.
Yes.
Who is the SCCU regional head in Pretoria.
And then
I take
yourself.
it in respect of the JIBA so-called prosecutions. And out of that number, I'm the last man standing.
Yes. And yourself?
Yes.
Yes. Are these black prosecutors?
All of them.
Yes. Is this an odd thing that Advocate Batoyi came and then systematically purged black prosecutors?
Yeah, of course, it's a worrying trend, and I take it that each and every NDPP will come into the office space. They will come with their own style of management or expectations or some of the background information that they will have. But unfortunately, in this instance, it looks like the real people that had a problem and shared the radar one was this so-called black prosecutors.
Yes. Now,
But of course, and correct me if I'm wrong, she seemed not to have had problems with Advocate Mlocho.
Oh, indeed.
yes.
And maybe because now we are on this point, I must take this opportunity without going ahead of you, Advocate Mkaitobi,
Indeed.
on the Advocate Mlocho's point. This point ties up with paragraph 8 that we have referred to about a decision. Also must be considered, I think, in relation to paragraph 13, the jurisdictional straddling point.
Yes.
And then also can be read in conjunction with paragraph 70 of Advocate Batoyi's affidavit. We may not have it right in front of us, but it is the the paragraph in which she was dealing with the jurisdictional struggling. When I read the statement of Advocate Mlocha, which you have annexed, after AC1, that statement of Advocate Mlocha is at page 6A-6. Of your annexures.
I have it, Chair.
You have it. Yes, it appears at 6A-6 up to 7. It seems to me, on the reading of the statement, that Advocate Batoyi seemed to have relied entirely on what Advocate Mlocha said or stated in this affidavit. Among others, to the effect that you led the prosecution team. And seemingly, it was on that basis that probably, correct me if I'm wrong, Advocate Batoyi seemed to have believed that you made or you took prosecutorial decisions. Am I correct?
Yes, I also suspected so initially, but as we go on, you realize that some of the opinions which were given to Advocate Batoyi, those will be the ones who precipitated the sort of narration that I made a prosecutorial decision. But in respect of Advocate Mlocha was the issue of that I encroached into his jurisdiction and he was not aware of that. As I did, that's why I attached this specific annexure here. It's to demonstrate that it couldn't be correct that I encroached without his knowledge.
If you look at AC1, paragraph 1.1.
I'm there, Chair.
Yes, that's where Advocate Batoyi says the decision not to prosecute in this matter, or rather it says, as you are aware, after reviewing the detailed internal report prepared by senior NPA prosecutors, I made a decision not to prosecute in this matter. Advocate Mlocha, previously employed by NPA as a Deputy Director of Public Prosecution, has testified at the State Capture Commission and filed an affidavit. In his evidence and in his affidavit, he states that you, as the leader of the prosecution team, sorry, it was not at that annexure. It is in her affidavit to the Zondo Commission, where she suggested that you were the leader of that Cator prosecution team, if I may put it that way. You acted as a lead prosecutor. Now, given that information, you remember that Advocate Batoyi had decided not to take any step until the decision or the findings by the Zondo Commission.
Yes, I remember that.
Now, she writes to you, telling you about this statement by Advocate Mlocha. Whereafter, she then writes to the President. If it is correct, as you state in paragraph 8, that you did not make any prosecutorial decision, does the issue of a jurisdictional strickling arise? You
No.
say it doesn't at 13.
Yeah, it doesn't arise here because the decision in respect of racketeering matters can only be made by the NDPP.
I'm trying to figure it out in my mind as to how Advocate Batoi comes to this conclusion, given the provisions of Section 2.1 of POCA. What do you think might have actuated her to come to that conclusion?
Advocate Batoi was looking for something that will stick about the conduct or otherwise of Advocate Chauke. So I think in the whole scheme of many of the cases that I've dealt with in the division, this case of Cator and the Mulli were the ones that she could have, and where she wanted to impute a particular misconduct on my part. But on the rating and even on the record, you will see it very clear that there was a prosecution team, there was a team leader, I was the coordinator in the supervisory role, and I could not have made a decision in terms of the law in any case in respect of the matters.
Now, we know, having listened to the evidence of Advocate Maema, Advocate Nopu, and having read some of the statements in the record, that the role that you played was very limited. Is that of a coordinator.
Indeed.
Now, when you look at the affidavit of Advocate Batoi at paragraph 70 of her affidavit, she seems, in relation to that aspect, the decision making, she seemed to conflate different concepts. Perhaps you can read it from the transcript, because that forms part of her evidence. In the transcript, she sought to explain the following, and I'd like you to assist us in understanding these concepts that she refers to. You may not have the transcript in front of you, but I'm going to refer to the transcript of the 25th, day 4, the 20th of November, 2025, day 4, page 28 of 98. This aspect was dealt with extensively, because she seemed to make much of this jurisdictional strategy and suggested that you acted unlawfully. I'm raising this well aware of the fact that this issue does not directly arise from the terms of reference. But because it was dealt with very extensively by her, where she also referred to the provisions of the Constitution, suggesting that you acted unconstitutionally and unlawfully, in the sense that you did not comply with the NPA Act. I would like you to deal with it and refer you to that part of the transcription where she said the following. She was asked these following questions. Advocate Mutlamanyana asked, yeah, maybe before you proceed, it brings us to the issue of a DPP, a Section 6 DPP of one jurisdiction exercising powers or functions in another jurisdiction. If you can explain that in full, the circumstances under which a Section 6 DPP of one jurisdiction can exercise his or functions in another jurisdiction. And Advocate Batoi answers as follows. So it is clear from the Act, the Constitution and the Act, Section 6 DPP has jurisdiction for all matters falling within his or her area of jurisdiction in which they have been appointed. In fact, the Mokoro inquiry found that there is not a circumstance that is in fact, if one looks at the Act, the Constitution, it does not permit that a section DPP oversees prosecutors. You can underline that word, taking place in the area of jurisdiction of another. Later, when I asked her questions, Advocate Batoy then read paragraph 70 of her affidavit, which reads at page 29 of 98. We quote, "The relevant part that is there is no provision in the NPA that deals with a scenario where a DPP from one jurisdiction can exercise powers in the area of another DPP." So it is not in the Act. It is not in the policy. It is not in the directives. A DPP cannot take decisions in respect of another DPP's area of jurisdiction. In other words, the DPP of one jurisdiction cannot exercise jurisdiction over prosecutions of another. It means that a DPP of one area cannot control, direct, run with, supervise, and coordinate a prosecution falling within the jurisdiction. I suppose she uses these phrases to suggest that these phrases means you were making a decision according to her evidence.
Which is unfortunate, Chair. Unfortunate in the sense that the decisions that she's making, she's referring to, are the decisions which the prosecution team would have communicated, which the ultimate decision, which the NDPP itself would make. I differ with her in terms of the interpretation of the powers of the NDPP in respect of allocation or delegation of work to a DPP of one jurisdiction or to another. That is common cause, even as I'm sitting here, to the extent that I'm on suspension. There's a DPP sitting in Johannesburg who's from the Northern Cape. Now, a blanket characterization of that a DPP from one jurisdiction cannot do work in another jurisdiction is legally flawed. Consequently, the same scenario that in the DPP case at end, I was overseeing a matter, not the division of the DPP in KZN. It was a specific matter which my understanding, and in terms of the NPA Act, Section 20 subsection 3, I think that the NDPP has got the power to delegate responsibilities to a DPP, which is not expressly excluded in the jurisdiction. My understanding is that even then, Advocate Jiva did not delegate me to make decisions in respect of the matter that was based in KZN. And I do not know how she came to that conclusion that I made the decisions, because the record is very clear. I made no such decision.
But assuming that even the prosecution team, that is the Advocate Emma's team, were delegated to make decisions, the decision in relation to this very Cator Manor charges were the poker charges.
Indeed.
And correct me, in respect of which only the NDPP could exercise her powers.
Indeed, sir.
meaning, if I'm correct, that even the prosecution team of Mr. Maema, they could not alone, without the NDPP deciding, make any such decision insofar as the racketeering charges were concerned.
Indeed, Chair.
So if my understanding following your answers is correct, that issue of you having allegedly acted ultra-virus because you exercised powers outside your jurisdiction fall away.
Indeed. I actually, in the initial stage of the reasons that I was asked and then I was advancing, and even when I demonstrated to her to say, look, this was happening, even on her own. She took the matter of the Cator mine and she gave it to Advocate Dikok, who was the DPP in the Western Cape, for him to have a look with the other people and the like. So if on her interpretation that is not doable, she could not have done that. I'm referring to the famous Dikok report.
And you're referring to Mr. Dikok's report in which you were exculpated?
In fact, no. The panel where Dikok sat with Advocate Tenga and Advocate Mamabolo, where they made assessment according to them that there were no justification for racketeering charges. But that report, of course, as I indicated, it also did not insinuate any misconduct on the part of the prosecution team or myself.
Yes, thank you, Advocate Persue.
Thank you, Madam Chair. Mr. Chauke, you know, we've covered a lot of ground in this exchange with the Chair. Do you still want to talk about your CV?
I can let you do that.
Well, we know now. We know now who Advocate Chauke is.
All right.
You told us even earlier when we
Yes.
started.
Yes. All right. So there's the first 10 pages we can skip.
Yes.
Okay. That's fine.
Thank you.
And then on the allegations, I think we've also covered a lot of this ground before, what the allegations against you are. So those 2 pages that seek to summarize the charges, we can skip. And then the background to the inquiry, I think everyone knows the background to the inquiry and the basis for the establishment of the inquiry. You may wish to say something about the opinions that appear from paragraph 47, just briefly.
Yeah. Thank you, Chair.
Yes.
Let me start with the one that is very significant of Advocate Dikok, which after the opinions of Advocate Nalane SC, Advocate Mayanecha, and his assessment, he made that recommendation to Advocate Batoy that there's no basis for her to recommend that there should be an inquiry into my fitness to hold office. I'm saying this because this specific memorandum was neither disclosed to me then or to the President when the application for my fitness to hold office was made. I'm saying this because Advocate Dikok, as you would have understood, he was the National Deputy Director of Public Prosecutions, who was reporting to Advocate Shamila Pato, and who was internal with experience, and who advised her that there's no basis for her to institute. But having said that, on the receipt of that, you'll see there is an opinion of prepared by Dr. David Broughton. He's a senior state advocate in an office. I think he's a legal advisor and the like, who she asked. And even the record will indicate here that he gave an opinion, and his opinion was about jurisdiction, put it that way, in the main. It did not deal with specifically in depth about the merits of the racketeering charges. And Dr. Broughton then made a recommendation that he thinks there is a case for me to answer in respect of the Boysen matter, the so-called Cator matter. But he also recommended that there is no basis for an inquiry into my fitness to hold office in respect of the Mulli matter. But you will see that Dr. Broughton was asked to make another opinion, which was to seek to get the reasons for her to be able to be justified to make that recommendation. Now let me get to the memorandum of prepared by Advocate Gathali. SC. I'm afraid, and I'm really concerned that
just before you get there, the opinion, I'm not sure how they have arranged this for you to make it easy for you to find them. But the opinion of Dr. Broughton, the first opinion, which is dated the 23rd of February 2023.
Yes.
I do need to spend a few minutes with you on that one because it became the subject matter of a discussion between myself and Advocate Batohi.
Yes.
Now that is at LO 00149. LO1. Yes.
00149.
Yes, 00149. Yes.
I'm there, Chair.
Now, when you look at LO 00163, okay, and under the heading analysis, okay, are you there?
Yes.
And the first subheading is the withdrawal of the murder and related charges in the Mulli case.
Indeed.
Yes. What did Dr. Broughton say?
In the light of the findings in the SCA-FUL decision, as referred to above, no recommendation is made herein that the Section 12, subsection 6A inquiry be instituted against Advocate Chauke relating to the withdrawal decision in the Mulli case and referring the matter charge to an inquest instead.
Now, so when you read that, what does that mean?
It simply means that Dr. Broughton did not see, like Advocate Cook, that there is no basis for an inquiry to be held against me in respect of the Mulli matter.
You see, the problem is this, the statement under oath signed by Advocate Batohi alleges that Dr. Broughton, she says, the reason I asked Advocate Harley is because Dr. Broughton did not deal with the Mulli matter in his opinion. Is that factually correct?
It's incorrect. It's actually misleading the panel, because the record is there. And I remember exactly when she was testifying here, and when she was confronted about it, she couldn't explain. Yes. She sought to say, this is not a recommendation.
Yes, no, I understand it, whatever its status is, but the fact that she says, the word that she used is that Dr. Broughton did not deal. Right. We can go to this. I think they've opened now for you in the statement of Advocate Batohi.
Yes.
Paragraph 173.
Yes, I'm there.
So if you read paragraph 173, it says, on 23 February 2023, Dr. Broughton provided me with his opinion. He concluded that I should make a recommendation to the President regarding the fitness of Advocate Chauke to hold office in respect of his involvement with and the handling of the poison matter. Now look at the following sentence there. He did not deal with the Mulli matter. Can you see that?
Yes.
Yes. Now, we've now gone through paragraph 45 of Dr. Broughton's evidence, and we've seen what it says. So it's not about what she said, or what he said. It's the fact that Advocate Batoyi, under oath, claimed that Dr. Broughton did not deal with the Mulli matter.
Which is a misrepresentation, Chair.
Yes.
Because the record indicates clearly that Dr. Broughton dealt with the Mulli matter.
Yes. Now, at paragraph 176, I think it's that same page. What does Advocate Batoyi say there?
He says his opinion was based once again on Advocate Chauke's handling of poison matter, aspect of it. He did not deal with the Mulli matter.
Yes. Now, what would you say about that?
It's a misrepresentation because the record as we have it indicates the contrary.
Yes. Yes. Now, we can then deal with how he dealt with it. You haven't clarified that it's actually a misrepresentation that he did not deal with it. Yes. Now, the way he dealt with it was that no recommendation is made.
Yes.
How did he deal with the poison matter?
On the paragraph 46 of his the opinion to LO 00163 to which you referred to.
Yes.
There's a thirdly there the boys and Catomania case. The evidence which Advocate Mlocha gave at the State Conduct Commission has not been presented to me, and thus I'm not at this stage not able to comment thereon, unless further time is afforded to me to search for the evidence on the official State Capture Commission website if same cannot be provided to me by the NPA. Advocate Nalan SC had regard to this evidence and the evidence presented by Advocate Mlocha at the Mkhoro inquiry, as well as the other evidence dealt with and findings made in the Mkhoro report relating to the boys and Catomania prosecution. Now, I don't know if you want me to deal with that or to go immediately to his recommendation in which he was...
No, I want you to deal with that up until paragraph 50 because...
Indeed.
There is a sleight of hand in what has happened here versus what Dr. Broughton actually recommended.
Indeed. Advocate Nalan SC submits as follows. If one reads Mlocha's affidavit to the police, together with the report of the Commission Mkhoro inquiry, dealing with the evidence of Jiba and Nogo, and his evidence at the Zondo Commission, it seems that Chauke's involvement in the prosecution was much deeper and more involved than simply acting as a coordinator. He went to the extent of asking Mlocha to sign the indictment. Mlocha refused to sign the indictment without the prosecution memo or report. The commission report suggests that Mlocha considered that Chauke was asking him to do unlawful acts. It is respectfully submitted that evidence presented at the Mkhoro inquiry and findings made in the Mkhoro report pertaining to Advocate Chauke's involvement with and role in the handling of the boys and Catomania case support a submission being made to the President for the institution of Section 12, subsection 6A inquiry against Advocate Chauke.
Now, if you can just stop there. You see, this is where I say there is a sleight of hand. The factual foundation for all of this that he is recommending is that you tried to force Advocate Mlotshwa to sign an indictment. Remember that?
Yes.
Yeah. Now, that submission was made here in this inquiry.
Yes.
And I asked the evidence leader who was cross-examining Advocate Mayem to show us where Mr. Chauke is attempting to force Mr. Mlotshwa to sign an indictment. You remember that?
Yes.
What did the evidence leader say?
He said, no, there's no way that it's the case, and he withdrew.
Yes, he withdrew the question.
Yes.
Now, when you look at the actual affidavit of Mr. Mlotshwa, which is what the chair was talking about,
Yes.
at 6A/6.
Yeah.
Read everything there and read it aloud. And show me where there is a line that says, Advocate Chauke forced me to sign an indictment.
Let me read it for the record, Chair.
Yes.
I, Cyril Simpiwe Mlotshwa, with ID, hereby state in English that I'm currently employed by the National Prosecuting Authority as a Deputy Director of Public Prosecutions, and I'm stationed at the Office of the Director of Public Prosecutions, Pietermaritzburg, KwaZulu-Natal. On 17 May 2010 until 9 July 2012, I was acting as a Director of Public Prosecutions, KwaZulu-Natal. Between January 2012 and March 2012, while driving to Port Shepstone, I received a call from Advocate Nomgcobo Jiba, who was acting as the National Director of Public Prosecutions at the time. She informed me that there was a matter where, because of pressure, we had to enroll as a matter of urgency. I informed her that I would first read the dockets and make a decision accordingly. She stated that the matter was urgent. I responded that I did not have prosecutors to urgently look at the dockets. She informed me that because she was at the OR Tambo Airport, she was going to call me later. She did not call me later. A few days later, I received a call from Advocate Chauke informing me that he had been instructed by Advocate Jiba to send a team of prosecutors to prosecute the accused in the Cator case. He told me that there were very sensitive security issues surrounding the matter. I told him that I was going to attend the DPP's meeting at VGM on 29 May 2012. So we were going to discuss the matter further.
So if you just stop there now, in the conversation you held with him, is there anything here where Advocate Mlotshwa says, in that conversation, Advocate Chauke told me to sign an indictment?
No.
All right, proceed.
On 29 May 2012, I attended the DPP's meeting at VGM. While the meeting was in progress, Advocate Chauke told me that Advocate Jiba wanted to see us urgently in her office. I went with Advocate Chauke to Jiba's office. In Advocate Jiba's office, Advocate Chauke told Advocate Jiba that he can't discuss everything relating to the matter as he had serious security concerns, and there was a possibility of investigation necessitating arrest or even advocates in the office of the DPP KZN. Advocate Jiba told the two of us that she had procured a legal opinion from Advocate Gerald Nel in the legal affairs section, stating that I can sign the delegation for the prosecutors who will be prosecuting in the matter. She further told us that the indictment would, in terms of this legal opinion, be signed by me.
So now just stop there. Who is telling Advocate Mlotshwa who is going to sign the indictment?
It's Mlotshwa saying that Advocate Jiba said he is going to sign the indictment.
Yes. Is there anything that says it's Advocate Chauke who's saying that he will sign the indictment?
No, not at all.
Continue.
I told Advocate Jiba and Advocate Chauke that I was going to sign the indictment only if it was accompanied by the prosecutor's memo or report detailing evidence implicating each accused as individual and the evidence implicating the accused as a collective. This meeting ended. On 12 June 2012, Advocate Chauke's personal assistant, Ms. Mameki Suping, emailed me only the indictment without the prosecutor's memo or a report. I thereafter exchanged a number of emails with Advocate Chauke, copying in Advocate Jiwa, her personal assistant and Advocate Tokoma Jokweni, requesting Advocate Chauke to give me the prosecutor's memo or report as per initial agreement. My acting appointment came to an end on 9 July 2012. I never had anything to do with the matter after the 9th of July 2012.
Yes. Now, let's go through that. So, according to this affidavit, is there anywhere where Advocate Mlotshwa alleges that Advocate Chauke attempted to force me to sign an indictment?
No, Chair.
Yes. Now, we go to the underlying emails that were exchanged at the time.
Yes.
So, these you will find under B2. So it's under the boys in bundle B2. Do you have those? I want to start at B579. You've got it.
It should be B3. B2, it's end. B3.
No, you are right. It's B3. Sorry. Yes, you are correct. So start at
You say 579.
Yes, because the emails are not sequential. They are in reverse. So it starts at the back and it goes forward.
What is the B number on that?
579.
Yes, I have it, Chair.
Thank you. So, if you remember the last paragraph from the affidavit of Advocate Mlotshwa said that Ms. Suping, who was your PA, sent him an indictment, but he says nothing about a message from you forcing him to sign the indictment. Remember that?
Yes.
Now, he says that was sent on the 12th of June 2012. Remember that?
Yes.
Now, we know that email at B579. It is dated 12th June 2012, 0129, from Zitmameki Suping.
Suping.
Yes. And it has no message. It is just an attachment.
Yes.
Indictment Cator. Is that correct?
Yes.
Now, thereafter, what we get is an email from him to you,
Yes.
from Mr. Mlotshwa to yourself,
Yes.
where he refers to a telephonic conversation.
Yes.
Now, the telephonic conversations that were held between the two of you are recorded in his own affidavit, where he says it was Advocate Jiba who says sign the, it will be signed, doesn't say sign it, says it will have to be signed by you.
Yes.
Yes. Now, he then says, kindly furnish me paragraph 2 with the prosecutor's memo or report so that I can have a wrap-around view of the matter. The report must also have the police station and case numbers so that we can open up the DPP's file. Correct?
Yes.
So far, nothing from you says sign this memorandum. sign this indictment.
Yes.
We then look at your response, which is on the 12th of June, 5:14 p.m. at page 578. Correct?
On mine is 577. On the B bundle, B3.
Your response.
It's B0057. 577. Yes.
No,
And also us, I think if you look at the numbering council, the first email was at 00578
8,
by
yes.
Mamiki Shuping to Mr. Mlojwa, which is the first one. The second one was from Mr. Mlojwa at the bottom of 577 to Advocate Chauke, and the third one on the same page, 00577, by Advocate Chauke to Mr. Mlojwa.
I see. Okay, then I think the witness has the same numbering as the panel,
Yes.
and I have a different numbering. So you say it's not 578, it's 577?
Yes, 577. The previous one of Mamiki to Locha is 00578.
Okay,
Yes.
no, that's
B00578.
well, let's work on 577, because that I think is consistent with the panel.
Yes,
So that's the email from you on the same day
yes,
with 1, 2, 3, 4, 5 paragraphs.
yes.
Yes. Now, you can read that and tell me where you find any instruction on him by you, on Mr. Mlocho, by yourself, to sign an indictment.
I can read the email onto the record, Chair.
Yes.
Dear Advocate Mlocha, who is the prosecutor that you are referring to? I have forwarded to you the indictment which has all the detailed summary by which you ought to be in a position to open your office file. I also forwarded to you details of the inquest with police case numbers, etc., to which you referred to Advocate Jokoma Joken for reasons that I do not follow and understand. The indictment with respect gives you the whole view of the matter. You are kindly and fervently requested to please discuss any issue, if any, with me. I really do not see any need for me to give you any report other than what I have forwarded to you already. Please, if I misunderstand you, make me understand. I do not want to play you or undermine your jurisdictional authority in any way whatsoever. There are serious issues of security in this matter, which, if necessary, you will be briefed about, which are not relevant to you, and I cannot expose such to you at this stage. I have also learned with utter dismay that you have now issued an instruction to the senior prosecutors that all dockets that are with us must be brought to you. What is not happening here, my brother? Please, if you have any issues again, talk to me or arrange that we see the acting NDPP urgently. Another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest, in view of the fact that you have been requested to sign the indictment, which must be preceded by your decision to reopen the inquest.
So I'll stop there. Now, what does that sentence mean? Because that's the only time there's a reference to the indictment, but what is it saying?
It's saying that we need to consider the issue of the inquest so that it should precede his signing of the indictment.
No, but what does it say about the indictment?
It says that which has been requested to sign the indictment, which must be preceded by your decision to reopen.
That paragraph, that passage that talks about the indictment, what does it say? It says you have been requested.
Yes.
By who?
By Jiba.
Yes.
Yes.
And then you can continue the rest of it. It's got nothing to do with you saying to him, he must sign the indictment.
Yeah. If this makes you uncomfortable, please indicate so that I may urgently take the matter up with the NDPP. I do not want to step on your toes. I was informed that you agreed and arranged with the acting NDPP for somebody from outside to do the prosecution in these matters. If you have now a change of heart, please indicate so that we may resolve it as soon as possible. Regards.
You see, this is the problem. There is no other correspondence in this case that deals with this, except what we've read so far.
Yes.
Now you have a scenario in which Dr. Broughton writes in a report that you gave an instruction to Mr. Mlocho to sign an indictment. You also have another scenario in which there is a finding by the Mokoro Commission that you attempted to force Mr. Mlocho to sign an indictment. But there is no factual foundation for any of these things anywhere.
Indeed, there is none.
Yes. And then you have the evidence leaders here just repeating the line, just repeating it without verification whatsoever. Then you have Advocate Batoi just repeating it as well without any verification whatsoever. When you go to the underlying documents, you find this is a big lie. What do you say to that?
The state capture narrative, Chair, is what is at play. People had to find a reason to try and justify that narrative that there is something untoward that this people or this person is doing, especially in respect of this Catomania matter. Yeah. That is, in essence, what it is, so that you can justify that people were acting improperly, inducing, forcing some people to do that which they are not supposed to do.
Yes.
It's a real narrative.
Yes.
And it's unfortunate that your colleagues would be found to be into that narrative as well, which I appreciate, of course. If you don't have the time, having gone through these things, you might find yourself being misled as well.
Did the Commission itself make any adverse findings against you in relation to those allegations?
Not at all, Chair. Chair will remember that the Advocate Batoi herself, she said, I'm quoting her verbatim, regrettably, the Zondo Commission did not make any findings or recommendations. I underlined that word regrettably because she was disappointed that the Commission did not make that which she expected.
Yes, thank you very much.
Yeah, I just want to ask. Thank you. Advocate Chauke, as you were leading evidence, amongst others, you stated that the opinion of Advocate Gok, which exonerated you, was not included in the documentation that was sent to the President with a recommendation that an inquiry be held against you. Is that correct?
From my recollection, that is correct, because I had it came to my knowledge. In fact, I remembered in the talks then in 2023 with Advocate Gok saying, I can't tell you, but I've made recommendation. I don't understand what's happening. So immediately when I was asked to say now I must respond by the President, I wrote to Advocate Batoi to say, oh, no, look, this is what's happening, and now it has come to my attention that there is a Broughton, there is Harley, and there is a DCOC memorandum which was not disclosed, to which I did not have sight. Please, can you favor them to me? How I got to know that is when I understood from the President, when the President was asking me to explain. So that's how I understood that this would not have been disclosed.
Now, in your view, was it proper for that opinion that was exonerating you to be not disclosed to the President and even to yourself?
It was improper, and I made that point even when I responded to the President. I indicated that it's unfortunate that this was not disclosed to the President, and neither to me.
Right. It is correct that the opinions from Advocate Hali, Advocate Nalani, and maybe Advocate Gok were sought after the full SCA judgment had been released.
Yes.
Now,
In fact, all the opinions. Yes.
and that is, maybe let's talk about the ranking. The ranking of power,
Yeah.
right? Now, as a lawyer, you get a decision which now becomes precedent. And thereafter, you go and seek opinions that, amongst others, seek to negate that very judgment of the Supreme Court of Appeal. Is that proper?
It is highly improper because you are second guessing the court. That's what it is.
Yeah. As an officer, I'm looking at this this report of Dr. Broughton, in particular this portion that we were dealing with at LO 00163, paragraph 45 thereof. LO 00163, the one that we just had now, no?
Yes.
Now, 163, ne? It's LO1. LO1.
163. Thank you, Chair. Yes, I have it.
Are you there?
Yes.
Now, it is clear from Dr. Broughton's opinion on that page at paragraph 45 in particular,
Yes.
that his decision not to recommend that the president considered subjecting you to an inquiry was informed by the judgment of the Supreme Court of Appeal.
Yes, indeed.
As an officer of court, what is your understanding? Can you then put the Supreme Court of Appeal judgment and put it in competition with other opinions that you seek to obtain?
No, not really, Chair. And the upshot of it is Dr. Broughton understood that principle, that once the court has made a decision on the matter, that's the end of the matter. If you are unhappy one way or another, you would have to indicate so by appealing or whatever. But absent that, you have to abide by the decision of the court.
Either live with it or appeal it.
And that is what it is.
Now maybe let's talk about
Sorry, Chair.
Advocate Batoi, thank you, because she is the person who decided to still insist on getting opinions and even seeking the president to take certain steps while aware of this judgment. Now, what do you think? Does she understand that the Supreme Court of Appeal judgment should rank as superior if we are talking about the hierarchy of powers? Or is it because of lack of understanding? And I'm saying this because you say Dr. Broughton understood. And our concern is the understanding of Advocate Batohi.
Chair, I want to believe that she understood, but she was desperate. Desperate in the sense that she needed to find a reason for me to undergo this inquiry. Because even if you remember, even when she was sitting here and then she was asked about the sanctity and the finality of the court, she agreed, but she sought to try and get a narrow decision to say before this, before that, which is irrelevant and irrational in itself. But yeah, I want to give her benefit that she understood the judgments. But from where I'm sitting is a source of desperation that she had to find something that she needed for me to undergo an inquiry.
Just to wrap it up, is it correct that the SCA judgment, the full SCA judgment, did not make a finding against your conduct in respect of the Mulli case?
Indeed, that is the finding of the Supreme Court of Appeal, that my decision in respect of the Mulli matter was rational.
Thank you.
Thank you.